Adjournment requests from item number 1 to 8.
Lordship, item number 8, in this case, we have filed rejoinder today only, Lordship. So it may be taken up next Tuesday or Thursday, Lordship, for disclosure.
What is this matter about? SSA क्या?
एक schedule लेबर regulation के लिए direction दिया है। Union of India. This is not SSA, I think.
What is this matter about?
Casual
Lordship,
workers.
regarding regulation of casual labor, Lordship, under LOA,
Yes.
Other policy, no?
Lordship.
Anyway,
But-
what do you want? You want to rejoin?
Yes, Lordship.
Take it.
They have filed Lordship rejoinder.
Mrs. R.
Yes,
Devi, learned advocate for the petitioners, last Union of India and another, seeks some time to file a rejoinder affidavit. So let such an affidavit be filed positively by the next date. Re-notify. Then we give you time in August.
Lordship, next Thursday,
Next Thursday is not possible. Huh? Minimum.
July, all this hearing surplus.
Can it be before vacation?
First week of August.
Lordship.
First week of August. Give a date.
Actually, Lordship, this
3rd
is
of August.
sixth round of litigation, Lordship.
I know. Therefore, we are not readily forthcoming with the with the order granting the request of adjournment.
Or July.
They should have done that. I don't think you have anything to
Today they
rejoin.
have.
Nonetheless, August first week.
3rd of August.
Don't ask for any adjournment thereafter.
9 to 15.
Item number 14 and 15, Lordship.
14 and 15, you have circulated the slip. No?
Yes, Lordship.
But slip has been circulated only in item number 15. Have you informed the council and
Yes, I have informed, Lordship.
14 and 15, 16 is something different.
No, 14, 15.
Oh.
Very good. As prayed for on behalf of the appellants in WA number 360 of 2014 and WA number 23 of 2017, both the appeals are directed to be listed under the same heading on, again, August, second week of August.
10th of August. (16 to 30).
Item 16 to 21, madam.
Yes.
Can it be on the 1st of June, madam?
What is the difficulty, Mr. Gogoi?
My senior, I am led by my senior counsel, D.C. madam. Can it be on that day? Some difficulty today.
When do you want it?
1st week of June, madam.
First week of June.
Madam, if not, it can.
You can have it in second week of July, when the court reopens after the rainy break.
After reopening.
After reopening.
After reopening.
All right. As prayed for on behalf of the appellants, let all these analogous matters be listed on 17th of July,
Would it be little bit late, next week thereafter?
4th of July.
24th. Highly obvious.
Let it be the 23rd of July. That will be a Thursday.
Lordship, highly obvious.
That is your Lordship. Item number 22, I have also circulated adjournment.
22 also you have circulated the slip. Today you have a large number of matters where you have circulated the adjournment slip. Who leads you in this matter?
Senior counsel P.K. Goswami.
All right. Then August.
Offline.
Yes.
3rd of August.
May I please read? Also, item 27 to 29, Lordship would be concerned of the Lordship.
Item 27 to 29.
Lordship.
Why?
Lordship, my senior has some difficulty to.
No, have you taken his consent? This is Satta Pirala and
Lordship,
56 acres.
Critical case, Lordship. In fact, in the main case, we have also, I have checked I have prepared the case, but in the main core case, Lordship, no affidavit or rejoinder has been filed.
No, has the
Other cases we have filed.
that judgment by Board of Revenue, has the translated and corrected version been supplied?
Lordship, like that.
Been
Yes, supplied. It is supplied.
supplied.
That affidavit may be required in.
That in the first case, Justice SK made his what order. But this is a very critical case for the state lordship, very crucial case.
That's all right. Because it concerns
not want-
parties and land in,
Yes.
Sutherland.
in a,
It has a huge historical thing, legacy, and it has been
Mr.
shattered.
Diganta Das was appearing, if I remember correctly.
Loss,
Hmm?
loss.
Then we keep this again in August. August
Or in the first,
August.
it could be,
August.
no difficulty, lordship.
as, do we say as jointly prayed for?
Maybe, lordship.
As jointly prayed for, re-notify both the appeals on, give a date in August,
6th of August.
6th of August.
Obliged, loss.
Highly obliged.
More or less.
May it please your lordship, in attempt,
Yes.
item 26, we have circulated a slip on behalf of appellant statement.
Number 20,
26.
what do we do then? In fact, we should not keep this day only reserved for hearing. As prayed for on behalf of, you appear for the state of Assam.
On behalf of additional AG, Mr. P.N. Goswami.
As prayed for on behalf of the appellant slash state. Let this matter come up for consideration. August.
6th of August.
Any other requests? For orders, item number 1.
It is your loss.
Yes.
Well, this is a review application in respect of land acquisition matter. So far as the high is concerned, your lordship has already passed an order on 20th of February 2026.
Yes.
That it will be taken up along with the main case. So my lord, no further order is required to be passed in the IE. And
Correct.
the
So,
matter.
so you can argue your review.
My lord. My,
My suggestion will be also today, in this matter, my colleague Gina is the same. He is in another court block. So in this case, doctor, we have already prepared one affidavit. It has been sent for vetting also. If
As prayed for. All right. So next week,
anything.
next week, as prayed, next week.
Next week. Then he may say rejoinder and all.
Can you serve the affidavit on Mr. Chaudhary in advance?
Sit the signed copy lordship immediately. I have.
And then if you have to rejoin, you also rejoin. In case, review, I don't think any rejoinder is necessary.
it's not necessary because the my lord.
All right, all right, all right. So don't take time on that ground later, as prayed for by Mr. Nayak, learned additional advocate general. Let this matter come up for consideration. And first week of, on 14th of July.
Right. Highly obliged.
Item number 2.
On the occasion, he said that Mr. Nandi, have you informed?
I have informed Mr. Nandi,
Ah,
but I am told, my lord, that since he is not the standing counsel
ah.
and he is not interested with the
Yes,
case.
you are.
For respondent four, my lord, I have yesterday applied for power. I have to pray for some time. I'm the builder.
You're the builder. Can I have your name, please?
That's how, my lord.
So and so, learned advocate has appeared for respondent number 4. Some time to put in his response to the petition. Let such an affidavit be filed on or before the next date. Re-notify on. Times in July.
Service on bank.
Bank is complete, my lord. All the, my lord, service and all the respondents complete.
All right. Yes.
29th of July.
Item number 3. Yes.
May please your lord, your reviewing order is in case number. Case number 164, my lord.
165.
164, my lord.
Yes.
Of the petitioner before the learned single judge is then case number 165, my lord. The third para. The petitioner is aggrieved by an order dated 27/12/2012 by which he has been rejected from his service in Assam Rifles on the ground of medical incapacity and overage. The medical incapacity was urged by the petitioner not to be ground of discharge, and in this regard, the petitioner along with other had approached this court by way of various writ petition, including 4710/2008, which was disposed of on 10/8/2012. The aforesaid branch of writ petition disposed of by the remanding the matter to the authorities to re-examine the medical status of the incumbent, including the petitioner. It is specific case of the petitioner that after such remanded through the white report dated 3/10/2008, he has been held to be unfit with the remark that specialist opinion is enclosed. Such the specialist opinion is later on dated 5/10/3 Mosundar. That is the case of the petitioner. My lord, then honorable court, that is in case number 163/6 last para, my lord. In view of the above matter, the impugned order dated 27/12/2012 is set aside and the petitioner is directed to inducted in the service as a trainee constable under the Assam Rifles. The authorities, however, are liberty to have periodical medical review of the petitioner as per existing rule. It is also made clear that the age of the petitioner shall not come in the way of the induction in as much as when the petitioner had applied for the post and his candidature was rejected on account of the age. My lord, against that order, we have filed one review petition, my lord.
That also was dismissed.
That was dismissed our.
Just a minute, give us a minute.
Yes, ma'am.
Let's go ahead.
Yes, ma'am.
सर ये क्या है ये रिपोर्ट था 5/10 का डिस्टेंस था 3/10 so on based on a sub report oh yes sir it is a specific petition that after such remand to write report 3/10 and 5/10 this is the ground. Yes.
Some of this.
Before,
But the order was passed later.
Order was passed earlier, report is later.
Then it was again.
So इसलिए बोला कि that instruction is also only ground. So that's why he's not gone into anything, that you cannot rely on a report which is subsequent to discharge.
Only confirmed. Yes, what do you have to say?
Otherwise,
Mr. Pathak.
my lord sees, otherwise the petitioner has been pursuing this litigation from the year 2001, your lordship.
But
The ground on which, just
they are rather hesitant.
one thing which I wanted to point out to your lordship, apart from the ground on which the learned single judge had set aside the order, the petitioner was said to be suffering from a deviated nasal septum. As per the own guidelines of the Assam Rifles, my lords, that is a temporary.
Mr. Pathak, that is not a problem at all.
My lords,
No, had it come to us before that,
my lords.
now for these 12 years, how many years? You were discharged, invalidated when?
2001.
2001. We are in 2026. Of course, this can't solely be attributed to you, but then when you were declared to be unfit for the second time
My lords,
and your services were discharged, this was by order dated 27th of December 2012. Is
my
that
lords,
correct?
My lords,
And then you filed a petition then. When did you file a petition?
2016.
So after 4 years. So not that you have pursued it with the diligence required of you.
My lords,
But on that slender ground, how do we do it? And of course, it will not be easy for Ms. Gyan to overcome that,
may I,
especially when the senior judge has, when the single judge has dealt with it.
may I make a suggestion for a
Now,
lordship
we could
consideration?
only say, let's be fair to you as well, we can only say that it was only a confirmatory report. It was based on a medical report. A specialist opinion is only confirmatory. But on that ground, could age and the medical invalidation, whether that could be brushed aside? That's the question.
My lords,
I mean, how do we justify? I mean, we are only looking at it from your angle
my lords, my lords,
or for the benefit of an employee.
my lords,
But then which court will sustain this?
my lords,
After 20, see, the order has to be passed.
my lords,
Order should be such that it is effected.
my lords,
It is effective and it is sustained.
my lords.
Now, after 26 years of your invalidation, on whichever ground, do we have any justification of asking your employer to take you back?
My lords, then may I make a submission for a lordship's consideration? In the other petitioners who had come along with me, your lordship, in their cases, the coordinate division bench had said that they should be given an opportunity to complete the basic training, and if they are successful, then they should be inducted. If a similar opportunity is granted to me, because otherwise it was only a temporary disability, let them conduct a fresh medical examination and give me an opportunity to participate in the and complete the basic training. If I am successful, then they may consider my induction. Otherwise, because 44, I understand your lordship, the age is because he has been pursuing you. If he is granted an opportunity, at least it will be fair for him also, your lordship.
Speaking from here, we are inclined. Speaking from mind, we are not.
If he is successful, if he is.
You know, how will he, I mean, even if he is successful, after 26 years of your invalidation, we are asking the employer to take you back. Of course, you'll agree for no back wages, no seniority, nothing, fresh appointment. But can we do it? That's the question which we are putting to ourselves.
There was a age limit at that point of
26
time
years.
for even induction. Now at this age, forget about age relaxation. At this age, can we do that you are at 44.
I'm 44.
So you'll be inducted at 44, which is not at all permissible.
What kind of training would be imparted to you at this age for a constable general duty?
Your lordship, in the cases
Normally people in army retire.
my lords.
Bad luck for you. And I don't know why you were invalidated. It was only a septum
My
problem.
lords, it deviated in
Severe airway inadequacy or obstruction. That's remedied by
it's
a minor
proce-
operation.
Minor procedure is required. My lords. The other petitioners who had come along with the present petitioner,
But why did you take 4 years?
my lords, at that,
After 12, you came in 2016.
I mean, he
It was not continuous. I mean, your diligence is lacking. You were perhaps happy. Maybe you, I mean, I don't know how to justify.
Then he has joined me. You filed a writ petition after that judgment was delivered.
Yes.
my lords.
So you are a fancy
After the judgment was.
a difficult case for us to sort of reject your claim.
My lords.
But then seeing the totality of the circumstances, we are not getting persuaded.
My lords, if he's
No encomiums to Ms. Gayan.
my lord,
That she succeeds is not a ground for her to pat her back. But the difficulty is that after 26 years, no amount of legal jugglery would justify our reasoning.
my lords, only
Whatever may be the
why I'm pressing this petition, because the original ground of invalidation, your lordship, was so trivial.
Where is the dispute, Mr. Patak?
My lords,
We are finding it even today. Why original? We are finding it even today.
my lords.
The proper course for the courts to have been to direct that in such cases, you must consider if it is an illness which could be removed by simple operation, do it, ask them to go for training and then induct in service. That was absolutely unnecessary, giving that leeway. But after 26 years, we would be very loath in granting that privilege to you. Especially in paramilitary. This is what? Assam Rifles. It's a paramilitary.
Your lordship then grants me an opportunity. I'll see if there is some precedent of something like this ever happening before your.
If you're trying to show us any precedent under Article 142, we don't have that power.
I understand that. But if, because other than that, your lordship, at this stage, I perhaps.
What kind of employer are they? For September. The only thing which is holding us back is this. Otherwise, the safest option is to ratify the judgment.
He's otherwise willing to be given an opportunity to, complete the basic training, and only if he's successful in it, then he may be considered. I have explicit instructions to that effect.
On this delay for us also, 2014, the revision system. What was the earlier division bench judgment?
The earlier judgment, your lordship, it starts at 46. In the directions, your lordship will find at page number 73. They start at the bottom of 72, in fact. The impugn order dated 27, I'm reading from paragraph 14 here. The impugn order dated 27/12/2012 itself indicates that the petitioners were enrolled into the Assam Rifles.
The difficulty, what we are seeing in this is, if we ratify the single judge's order, the difficulty is that it will open a floodgate. Then this time limit would be completely, abandoned. That would give a platform to very many.
Otherwise, this present petitioner is the last, I think, remaining candidate from that first batch of petitioners who had come before your lordships in 2012. The judgment of 2012. 2000, they'd come before this court in 2008.
Give us some very strong reasons. We have, the heart is getting better of us.
He's seeking some time to have some water.
There are fewer instances when we get stuck up like this, especially when it comes to decision making. I'm sure you must have been gainfully employed in the meanwhile. I'm sure. I don't want a disclosure from you now, but I'm sure that you would have been gainfully.
If I may be frank, your lordship, his wife left him because he lost the job. I mean, his personal life, he's also been suffering a lot. Those are my instructions. I mean, for people from their humble backgrounds, a government job, your lordship, holds a lot of weight.
The only difficulty, Mr. Patak, is that if we ratify the single judge's order, it shall not be sustained. You shall not get into it.
I'm sure they'll challenge it.
You may succeed
My lord.
here.
Please, a phrase.
We give you one more time. Let's not allow that petition today. There is a stay of the operation of the judgment.
No, my lord.
Ah,
After this is coming, my lord. After.
There is a contempt petition pending, but we are not, since there's a writ appeal pending, we are not really pursuing that. Because
For induction, medical test results like in a fee. For
क्या है?
induction.
हम भी सन की बात क्या करें?
वो तो क्या ना करें? Legal societies में induction के लिए भी है नया medical test, not only for this navigation party. Otherwise, whether is fit.
Where are those orders where those persons who were invalidated, they were again put to that test and they passed?
my lord, the judgment of the division coordinate bench, your lordship will find at page number, it starts at 66. And the directions, they start at the bottom of page number 72, paragraph number 14. This is a judgment passed by a coordinate division bench.
तो induction में जाने दिया इसके लिए induction के लिए भी टेस्ट हो सकते हैं whether is fit to go for training events 40 years 44 years so इसमें अगर physical test वगैरह
And
हो सकते हैं
so one of the sample orders that have been passed pursuant to this order, I have enclosed along with the my petition that your lordship will find at page number 64.
That doesn't satisfy the doubt which we have in our
My
mind.
lords.
My lord, the division bench orders are related to the person who was medically fit in appealless medical court.
we they have admitted that the report and again a special report was not necessary at this point.
Take it up. We have heard Miss A. Gayon. CGC.
Seriously.
The learned CGC for the appellant and Mr. K.P. Pathak for the respondent. The respondent had been provisionally selected as a general duty rifleman in the year 2001 under the Assam Rifles, a paramilitary force under Ministry of Home Affairs, Government of India. However, such selection was subject to and conditional on his passing a final/confirmatory medical examination. Paragraph. During the confirmatory medical checkup, at the relevant medical facility,
The respondent was declared medically unfit because of a medical condition described as DNS, right severe airways inadequate. Perhaps the medical unfitness was for the reason of deviated nasal septum on the right side with airway obstruction. This is a malady which in our estimation can be rectified by a simple operation. Yes, we are not medical experts. The learned counsel for the respondent has submitted that this was an ailment which was very temporary and could have been rectified even by a smaller surgical intervention. Nonetheless, the respondent was discharged from force on 31st of October 2001, which order was based on the recommendation of Invalidation Medical Board. Precisely for this reason, namely his not coming out successful in the medical checkup, he could not complete his basic training, and therefore was not held to have entered the force for all practical purposes. The discharge of the respondent was questioned by him before this court by writ petition number 4710 of 2008, which was disposed of with a direction to the Assam Rifles to constitute a fresh appellate medical board, preferably including a specialist in the relevant field of disability, to re-examine the respondent for his medical fitness, for his confirmation as the rifleman in the force. The respondent was, pursuant to the orders passed by this court, examined by the appellate medical board on 3rd of October 2012. But he was again found unfit for the same medical reason. The rejection of the claim of the respondent was communicated to him on 27th of December 2012. Next. After about 4 years, the respondent referred a fresh petition, bracket WPC number 5172 of 2016, mounting a challenge to the communication of discharge dated 27th of December 2012. The learned single judge noticed that the appellate medical board had examined the respondent on 3rd of October 2012. But there was a specialist's apostrophe opinion on record, which was of a later date. That's of 5th of October 2012. It was thus argued by the respondent before the learned single judge that flouting the directions of this court, the opinion regarding medical disability was arrived at by the appellate medical board in the absence of an opinion of the specialist. Let me just let it come the way it is. What have I said? In the absence of an opinion of the specialist. On that score alone, the learned single judge quashed the order of discharge dated 27th of December 2012 and directed for the induction of the respondent after allowing him to undergo the requisite training, and such induction, it was observed, would be subject to his passing the tests with relaxation in the age requirement. We notice, next part, we notice that all this has consumed time and 26 years have passed since the discharge of the respondent. To be fair to the parties, an opinion of the appellate medical board cannot be brushed aside merely because the opinion of one of the specialists is of a later date. The appellate medical board would surely have comprised other specialists in the field. So the counter argument would be that in that event, there was no justification for taking an expert's opinion. And that it was only on the direction of this court to preferably have a specialist in the medical disability complaint against the appellant of being member of the appellate medical board. Appellate medical board. Mr. Pathak, learned advocate for the respondent, however, submits that it cannot now be doubted
regardless of the respondent having opposed the court after 4 years of the rejection, of the invalidation, of the medical invalidation, of the discharge, that the authorities had made up their mind to ratify the discharge order passed in the beginning, notwithstanding the fact that the disability noted could have been easily addressed without losing time. However, there is nothing on record to indicate that there were nothing on record to indicate any malafide, except an official recalcitrance or obduracy in not reviewing their own decision. So the question which confronts us today is whether on that ground, after a lapse of 26 years, the respondent could have been directed to be reinstated in service and to be imparted required training by relaxing his age. So considering the totality of the circumstances, we request Ms. Gayan to take instructions whether it would be possible to accommodate the respondent in a non-combative duty subject to his passing the requisite training after relaxing the age requirement. We have said so for the reason that we find the initial discharge order on grounds of medical disability to be very doubtful, as it was never explored by the employer whether such disability was temporary and could be removed by minor surgical operations, and whether such disability would have prevented the respondent from exercising his normal duties as a rifleman. Awaiting the response of the appellant, the matter is adjourned. This is something which is beyond our mandate, but we have done it because we feel strongly for the person. For septum, for sneezing. Anyway, this is not legally very sustainable order, but let's see if you can give him a non-combative duty. Let's see.
I'm deeply approved.
Must
28 July.
Absolutely beyond our remit, but anyway.
Item 4.
Attempt for can it time be possible for the time being, well, arcade in law.
No, pass over. He has to answer, Mr. Kaushik. Now there's the second petition. We have already heard you. You are a scientist of great repute. This claim is yours.
Well, I have taken the instruction, Malad.
We had asked you to take instructions
Yes,
to
I have
withdraw
already
the.
taken the instruction, Malad. I would like to withdraw, Malad. However, Malad, with some kind consideration, Malot, as since he is retiring on February 2027. And in the last date, Malot, the Learned Senior Council has fairly submitted that there is a policy for asking for choosing the home district if there is a within the.
You file a petition that shall be considered.
Malot will give some observation, Malot.
We'll leave that liberty to you.
Yes, I'll the liberty to choose.
And
Malot.
where is the other petition? This is the same petition. This was the same case which
Only
was.
one petition.
Now, if we advert to the facts, perhaps that also would not be.
We'll simply
We will allow you to withdraw this petition
with liberty
with the liberty to approach the respondents
for posting as per policy.
for posting as per policy, for home posting as per policy in the last leg of his service. Consider it. Consider it. Now, all these grounds we have not, it has not found favor with us that he is up to such big research that his transfer would cause some national damage to national interest and all that. That's
If
all.
it has already been.
Some material is required to make a petition motion.
Anyway, after some arguments, Mr. B. Kaushik, learned advocate for the petitioner, seeks permission to withdraw this petition in order to make a representation before his employer / respondents, consider his case for his transfer to his home district in the last leg of his service, as he is shortly to retire.
February 27.
He's due to retire shortly. Dismissed as withdrawn with the liberty aforesaid, with the hope and expectation that any representation filed by the petitioner shall be considered by the authority.
Grateful.
And he shall be communicated the outcome, and he shall be communicated the decision forthwith.
Item 5 and 6.
Yes. Oh, yeah.
Sir, in one case, state is appellant, where Mr. Bhattakur is responding. And another item 31 also, I think similar. Huh?
एक ही साथ सुनता हूँ।
Exactly.
उसको भी रखो 31 को भी निकालो।
In fact, lot of 31 has been decided on the basis of a judgment passed by this honorable court, I mean the divisional bench. And the division bench judgment is there, Lordship. That judgment was.
In 3 cases, division bench has been. First is, in 2 cases, except Mr. Bhattakur's case,
That is-
all these cases, Ujjwala Nazari, then Upendas and Nisive Asumi.
I'm relying upon Ujjwala Nazari. In Ujjwala Nazari, Lordship, Mandrila and Ujjwala, they were even in the same division laws. Exactly.
Still, you just start your arguments.
31 of item number 6. Item number 5. Which item, Lordship?
At number 5,
Principle will be same, your argument will be same in all the cases,
So then, in that situation,
except the item.
Item number 6.
the option is yours. You want to argue Geeta Burman,
Yes,
you're at liberty.
Yes.
But the better option, according to us, would be if you address us in WA number 392 of 2015, the Commissioner Secretary to the Government of Assam versus Ratan Basumatari and 9 others.
Not a Ratan Basumatari is an old matter, Lordship. I was not appearing in that matter.
All right.
That matter has been tagged with along with Gita Burman, Lordship. So.
All right. So Geeta Burman. Geeta Burman.
वो तो हम dismiss करेंगे, इसमें कुछ नहीं है, वो final है। तो this is already in 1,200 people, बाकी नहीं issue है। इसको छोड़िए सर, ये district is independent legal.
All right. This is of 2015. Long time has passed, we will not come to that. Anyway, we argue this.
I blocked.
Gita Varma.
Okay, ultimately, in this matter, in terms of lordship direction, I filed one additional affidavit in this matter. If lordship comes to the additional affidavit.
He gave some directions also.
Yes, that's.
To respond.
It's not from page 144. Here the husband of the petitioner was appointed, engaged as a master of lordship in the.
Page 144.
144 lordship.
Yes.
I'm slightly referring to the facts. He was appointed as engaged as a master worker on 17/9/1881. Then he was upgraded to work search on 8/9/1996. He expired on 2/11/2011 after 30 years of service losses. Thereafter, lordship, his wife, I mean the deceased person's wife, played for family pension. And Learned Single Judge was pleased to dismiss the petition. Accordingly, this appeal was.
I think employer also sent a proposal for pensionary window.
Yes, to clarify that position of the lordship, this additional affidavit was filed. If lordship comes to the affidavit, lordship, which has been filed by the chief engineer, BW Roads. Lordship, I am reading from paragraph 3. Paragraph 3. That the Public Work Road Department, which has been arrayed as a respondent number 1, 3, 4, and 5, in the instant writ appeal, has already filed its affidavit in opposition in response to the averments made in the writ petition being WPC number so and so. However, on 28/7/2025, when the present affidavit came up for consideration, and it was pointed out to the Honorable Court that in the appeal filed by the appellant with petitioner, for the first time a claim has been made that the deceased husband of the petitioner was working against a sanctioned vacant post. The Honorable Court, by passing its order dated 28/7/2025, directed the respondents to obtain instruction and file affidavit as regard one, whether the late husband of the appellant was employed against sanctioned vacant post, and two, on account of possible oversight of by which the name of the late husband of the appellant was not included in the list of beneficiaries for regularization.
You have correctly formulated the issue. This is the question which we have in our mind. Otherwise, we would not have gone deep into it.
Yes. So far as the first issue is concerned, engagement against a sanctioned vacant post, that we have denied. He was never engaged in any sanctioned vacant post. And so far as the second
He was
issue.
never engaged on any sanctioned post.
No.
That has been denied.
Paragraph 5.
Read that.
Paragraph 5, Lord. As regard the first question put forth by the Honorable Court as to whether the deceased husband of the appellant was employed against a sanctioned vacant post, the deponent herein most humbly begs to state that the husband of the petitioner, namely late Sutku Bormon, was initially appointed as Master MR against labor on 17/9/1981, and subsequently he was temporarily engaged as a work search stopper, provisionally for 3 months only, by the office order dated 7/8/1996, that is Annexure 1, and allowed to continue as work search stopper by the office order number so and so dated 18/12/1997. It is pertinent to mention that late Sutku Bormon, that is the deceased husband of the appellant, was working as work search stopper, and he was never appointed against a sanctioned vacant post. Further, the department maintained a service rule in the name of late Sutku Bormon and not a service book. It is pertinent to note here that a service book is distinct from a service rule, whereas a service book is a comprehensive detailed record of an employee's entire career, including all administrative actions from recruitment to retirement. A service role, on the other hand, is a simple record, often used for specific purposes such as tracking attendance, absences, and other related information for a defined group of employees, often for a particular period of presence. Furthermore, Letchutku Borman was engaged as a master before 1993 and later as workshop Sokidar after 1/4/1993. Masteral and workshop are different types of engagement as they differ in their purpose and conditions. Whereas masteral laborers typically engage for daily or short-term tasks with their attendance and wages recorded on a masteral document. On the other hand, workshop employees are engaged for specific projects or works and are often associated with government departments. These engagements, that is MR or WC, are different
Under
from
under
lecturers'
which
substance.
any project against which this man was appointed as works as Sokidar.
Any project, whether it was of a permanent
No,
character.
It was not even a project. No. Sokidar works as Sokidar.
No, no,
No,
which
no.
work charge is always
Only
against a
for
project.
work
Because the
It was-
payments are made through a different
That is the
fund.
point submitting lordship. It was not against any project also. It was just simply appointed as work servant.
No, but what was the purpose of converting him from muster roll to work charge?
Lordship, so far as master.
Because you see, work charge, technically speaking, if you go by Jaswant Singh's ruling, Supreme Court, State of Punjab versus Jaswant Singh or Jaswant Singh versus State of Punjab, there they have explained what work charge is. Normally, work charge is for a term, for a period.
Not so.
Or
Say
It's a particular.
Brahmaputra development project.
Yes.
And somebody employed.
Yes.
But if it partakes of the character of a permanent organization, then perhaps it is difficult, and most of the states have come out. And in fact, you, in the state of Assam, you as an employer, you have also come out with a circular that anybody having been converted into a work charge establishment and continuing for so many years will get an opportunity if his appointment date is before or after, there is a cutoff date, and he shall be granted a temporary government servant status. With temporary government servant, he becomes pension.
regularized.
Hmm?
Government.
No, regularize is later. Now, those whom you don't regularize, you have a provision for giving them temporary status.
It is not exactly temporary status.
No, this is, I
So far
understand.
as that is the undertaking.
We are only telling you that this is the process by which you convert your one employment into the other. Well, normally it is this. So if it were not a project, then perhaps he was engaged as a permanent, as an organization which was permanent in nature. And his duties also were of a permanent person, permanent chowkidar.
But without having any.
We
not having any
dispute
sanction.
that.
Yes.
Mr. Naik, we are not
Not
disputing
disputing,
that.
yes.
For one person, we are not going to tinker with law.
Yes.
But we need to know why work charge without a project? Then why should it not be considered in accordance with the judgments pan India that it was a permanent kind of an engagement and therefore pensionable, at least for family pension, not pension, but family pension he should get. Why not?
Because
That
this
is the question which we ask. And especially when your own, when the superintending engineer writes a letter that his name was excluded from that list only for the reason of oversight these days is used as a different expression.
Addressing that issue also. If lordship comes to paragraph 6.
while we are putting this question, you have raised this point that work charge is something different against one and so forth. That is in the clarified, and it in also Prem-Singh specifically said what should be the nature of a work charge employee in the context of just one Singh. So Jaswant Singh was dealt with in Prem-Singh also.
Lordship, Prem-Singh is basically.
I think
No, on this point, I am not going to the
Mr.
Prem-Singh.
Nayak, we are going to suggest you, I mean, we will consider the feasibility of suggesting to the government that they should come out with a circular, with a law with respect to work charge. So far as family pension is concerned, like in other states. Otherwise, I mean, you keep on getting such litigation where you have to contest tooth and nail.
In fact, lordship has already decided. This issue has, I mean, specifically decided.
In Upendas.
in Upendas, Ujjalan, there's so many judgments. are there. Otherwise, it's a decided issue, Lordship. So instead of going into all the materials, Lordship, I just would have simply placed the judgment.
Okay, okay, as per your convenience, you please.
But Lordship have specifically asked a question, why his name was?
Yes.
Is that question, Lordship, it comes to paragraph 6. That as regards to the second question raised by the Honorable Court as to whether on account of a possible oversight by which the name of the late husband of the appellant was not included in the list of beneficiaries for regularization. For such mistake of the government, there should be such strict reading of the scheme is in order to avoid making payment of family pension to the widow of the deceased employee. The deponent most humbly begs to state that in pursuance of Cabinet decision dated 22/7/2005, the Finance Department had letter number so-and-so dated 22/8/2005 concurred to the creation of 5892 numbers of different workers grade posts and 25,069 numbers of different grade posts for the purpose of regularization of service of equal number of eligible workers and master workers of 9 departments of the government of Assam, who were engaged prior to 1/4/1993 on the basis of the proposal from the department. In the Finance Department letter dated 28/8/2005, it was clearly mentioned that the post to be created would be personal to the respective MR workers, and as soon as posts are relinquished by the respective worker, the post would get abolished. It is pertinent to mention that Government of Assam by letter number so-and-so dated 31st October 2006 instructed the Public Works, Agriculture, Animal Husbandry and Veterinary, Water Resource, Transport, Irrigation, Public Health Engineering, Soil Conservation and Handloom Textile and Sericultural Department to stamp proposals for regularization in respect of those MR workers who were engaged by the department prior to 1/4/1993 and who have been rendering uninterrupted service since their joining and who were left out in the first phase. Accordingly, proposals were forwarded to the Finance Department from various departments for regularization of services of the left out MR workers engaged by the departments prior to 1/4/1993 and who have been rendering uninterrupted service since their date of joining.
This will be personal. This is now going to open the learning.
So even after 2005 lawsuit, another notification was issued in the year 2006 to consider regularization of service of the left-out master and worker. Then lawsuit will come to the next paragraph. However, thereafter, Umartibi and other judgments came to be pronounced by the Honorable Supreme Court in paragraph 53 of the Umartibi judgment.
Bad luck for Mr. Burman that before his name could be inserted in that list, Uma Devi, and that is how you treat. But here, Uma Devi prospective, no?
I'm coming to address that issue. Lawsuit will take case 50. Case 50, Uma Devi, last 4 lines lawsuit. Last 4 lines, 5 lines. Felix lawsuit, if lawsuit takes up
Yes.
6 lines from bottom in that particular paragraph lawsuit. We also clarify. This is paragraph 53.
Yes.
We also clarify that regularization, if any already made, but not sub judice, need not be reopened based on this judgment, but there should be no further bypassing of the constitutional requirement and regularizing or making permanent those not duly appointed as per the constitutional scheme. So this is the hurdle, law, so basic hurdle. Last 6 lines of paragraph 53 of the Madhyavi judgment.
Yes. Basic consequence to stop the procedurality of the entry. But when we have
Yes.
That has been clarified.
So that was the superior and face lawsuit after 2006. Next line lawsuit. The last 6 lines of paragraph 53 of the Umadevi judgment clearly impose the restriction by clarifying that regularization, if any, already made by but not sub judice need not be reopened. I'm skipping that paragraph. Lordship has already read. Next paragraph, Lordship. Further, restriction was imposed by the Honorable Gauhati High Court in this regard, by which order dated 17/5/2006 passed in WPC number so and so, that is Jitendra Kolta and others, reported in 2006 2 GLT 65. This is a full bench judgment also. Next paragraph. In fact, the state of Assam by way of filing, this is important also, we can be considered this paragraph. In fact, the state of Assam by way of filing an application being MC number 5972012 for grant of leave of the Honorable Court to implement the policy for regularization. In the said application, a Honorable Division Bench of Gauhati High Court by its order dated 27/3/2012 was pleased to decline to grant the prayer by holding.
They had to know this policy. You don't seek leave of the court. You have
to make
you
a
have the
policy.
executive, you have to make the policy. Why did you have to go to court to take permission? Why did you have to go to court to take permission?
Because
The court should have at best restraint from saying that we don't pass orders under hypothetical situation. You come out with a law, you come out with a proposal, we'll test it constitutionally. We are not teachers here.
My understanding is that it is clear from Umadevi's judgment that if someone who does not fulfill the conditions.
All right, so you don't come with that policy. But where is the question? Where is this concept of permission to come out with a legislation?
In the meantime, Lordship, we already declared a policy in 2006 that we are going to regularize the left out master workers left out in the year 2005. That is why, as it was not in terms of paragraph 53, Lordship, that is why we filed that miscase, Lordship. If Lordship comes to Annex 4, Lordship, that is the order passed by the Honorable Court, Annex 4.
Mr. Nanak, just clarify. In Jiten Kolita, the question was, the policy was for regularization of master roll and workers. But in different single benches, the regularization was directed on to ad hoc, temporary, many employees. Therefore, a divergent view was there, whether it will be applicable to workers, casual, and to all others employees who are temporary, ad hoc. And in that context, Jiten Kolita's judgment was passed that this cannot be allowed.
Today I am not having Jiten Kolita also. In Jiten Kolita, Lordship, ultimately it was held that the policy for regularization of 1995 initiated by the state government was not a valid policy. And 2005 policy was almost similar as it was mentioned in that judgment only. So 1995.
Did court set aside and the further paragraph in Jiten Kolita saying that we are not going to,
issues are concerned.
and it was not individual, it was a passing comment in Jiten Kolita. No determination was made. We cannot approve if we go to that specific paragraph.
That specific paragraph is there, not to promise, I can place the judgment. It was clearly mentioned that policy of 1995 was not a valid policy. That line was true. If Lordship comes to page 164.
Yes.
164 also. This is Annex 4. Annex 4.
It's not already made. 1 year ये उसी policy के तहत बनना है इसका oversight इसलिए this is not sub judice.
164 also.
Yes.
This is the judgment also. In fact, the author. The issue taken up by way of this petition arises from letter dated 21/2006, received from Srimati Tarini Deka regarding conditions of test school. So the different issue, Lordship. There we have shown the reason for scarcity of manpower. Test 2. The court appointed a committee to visit the said jail and submitted a report. On due consideration of the report, it was noticed that a regular employee was required to be posted for maintenance of housing. A statement was made on behalf of the state of Assam that the workers already working on casual basis may be posted as regular employees as per policy of the state for regularization. But order dated 1/11/2010, it was observed that no order.
Just a minute.
166. This is not a question of regulation. No more regulation. We are not we regulation, but we cannot restricted the service. We want to even say constable to be pensioners. Then I think exception is a normally should not be maintained. But pension statute, that is at oversight. We assume we are not conscious to do it, and must be we will not succeed that we will succeed to channel for this. This will come. So, I'm very clear, the direction from regulations. In this unnecessary against it's not subjudice. It was never a question whether we should get or we should not. It died in that case. Otherwise, and when you were very sure that we had been appointed to a serving from before the cutoff people, then this is should not be true. It's for the regulation who were not members of the legal community. No, that's people already. In terms of independence, this is you get share of membership. When you have selected your PCL, you have displayed integration in a given. Therefore, they will be integration premiums for specific so I think the snake post. That was it will be personal and this integration for the tax service presidential, no presidential.
Yes. You can take your seat, mister. Yes.
165 also.
No, that we have seen. That we have seen why the prayer has been declined.
Yes.
No, the reason is if the state cannot regularize casual workers as per law laid down by the Honorable Supreme Court, we fail to understand how we can give direction to adopt a policy
So that was
which may be in violation of a judgment of the Honorable Supreme Court. We accordingly decline to grant that prayer. The difficulty is this, that you projected this as a different kind of a permission which you are trying to take. Now, we are not laying blame on you. We are not even questioning the wisdom of the honorable judges. The question was this, you should have said that before Uma Devi came, we had already taken a decision. So it is no longer sub judice. Now these are facts, and by virtue of that, we have already regularized that Uma Devi in no uncertain terms says that what has been done will not be reopened. But whatever is sub judice means that sub judice does not necessarily mean that you are contemplating of doing. Sub judice means when a matter is
Pending.
brought before the court and is
Pending.
pending consideration. No. So I think no judge, no bench would have given you this liberty of passing a law or a resolution or an ordinance against the verdict of the Supreme Court judge. But there was no requirement for you to do that. If you were conscious about your own workers as an employer, this permission was unnecessary. Absolutely unnecessary. Anyway, those are of those days. You may not have been there. We were not there. So let us not question it. Now, then what happens?
Then if lordship comes to page 166. Page 166, it's an office memorandum.
Number A, we have seen no more regularization of muster roll or similarly placed workers can be undertaken by the state government, even if such workers were engaged prior to 1990.
1 and 2 lordship. Second, B lordship.
So here,
B. A lordship has read, B is there. No more regularization can be undertaken by creating supernumerary posts for 1 day in respect of those workers and MR workers who were engaged prior to 1/4/1993 but died or anything. So that is no creation of supernumerary posts.
Therefore, we have to be very careful. मतलब वो बात कर रहा है नहीं के सकते भाई हम नहीं लेंगे आप इस कंट्रीब्यूट स्लिप प्रश्न ही करना है देखते हैं सब बाहर देखते हैं बहुत सारे लोग सुनते हैं पर एक ऐसे देखते हैं जिसको
Lots of this notification was put to challenge.
In Upendas.
In
the already before a single.
Yes, single judge said
Let us say
this
in
notification.
Upendas.
Then Upendas was filed by the state. And in the Upendas lordship, 4 division bench, honorable division bench interfered with the judgment passed by single judge. And the situation was reversed. Therein court said, no direction can be passed for regularization even for those who were appointed prior to 1/4/1993, and no consequential benefit like pensions can be granted to them. So matter stands there. No regularization, no consequential benefits. It ends there. Thereafter, also we issued another notification of 2013. The policy for regularization we still follows, but it is only for those lordships who fulfills the 3 conditions as laid down in paragraph 53 about the Gauhati judgment. That is, he is engaged prior 10 years prior to date of Gauhati judgment. He was engaged against a sanctioned vacant post. He is continuing in that post without any protection of interim order passed by any court or tribunal. If these conditions are fulfilled, that we consider their regularization. And so far as these petitioners are concerned, he is not one only lordship. There are so many persons.
This question is not very interesting. Sustaining and what is putting in the this is the year I'm going to discuss with you, but it is going to be instructed. That's it. We have to do a question to the side. With all these background, we are not looking for authorization. Exception given to the law, individual mention that he is not before these was. So that can be reasons now the government. Number 2, now 52, the concern will says
Then in normal course, pension may not be using to also employ. It is not an exclusive use. They will consider in view of this subsequent adjustments of Supreme Court. We are not even directing the vehicle. Most of them speaking. देखिए रूम देखिए
Yes.
Lordship, first judgment I am placing Lordship, this is 2008-10 SCC Lordship. 2008-10 SCC 1. Yes, sir. This is down is from there.
What is name?
This is official liquid.
Huh?
Official liquid.
Official liquidator. That Uma Devi's judgment will be applicable, should be followed by all courts.
Only 3 lines. So Lordship will allow me to read only 3 lines. This is paragraph 75.
Give your slips, your book slip can only get it.
ये official liquidator. ये है इसका judgment है official liquidator. ये मानना लिखे सर ये एकदम राफ है.
First 4 lines, paragraph 75.
He makes the land state of America. Then he will rely on the proof. Then he will release the. These people has been Indian understanding how can one be.
Tell me. Mr. Nayak, you give your book slip. In the meantime, we come back after 5 minutes. In the meantime, he will have the books. Give your slip. I think you'll be referring to Prem Singh. You'll be referring to Prem Singh also.
Prem Singh, Prem Singh already has taken care of by the Supreme Court.
In Uday Pratap.
In Sunita Burman.
Huh?
Sunita Burman. Same case.
No, whichever book you want to know. We are coming back in 5 minutes.
Okay, first judgment I'm placing lots of, that is Uma Devi lots of 2006 4 SCC 1. Paragraph 53 lots of has
Oh,
already.
that's all right. Leave that. We have read it number of times. You read it out.
One paragraph 52 lots from Uma Devi. Now I'm just reading the conclusion in that paragraph also. Reading 4 lines also. The classical position continues. And a mandamus could not be issued in favor of the employees directing the government to make them permanent, since the employees cannot show that they have an enforceable right, legal right, to be permanently absorbed, or that the state has a legal duty to make them permanent. That is one conclusion, Lord. What if this position has been reiterated in the official liquidity law in paragraph 71.
Paragraph?
2008 paragraph 61.
61, 71.
71 I read long. This is
61, yeah.
61 official liquidity.
71 or official liquidation?
71
71 on that.
71 no, 75.
75 of Uma Devi.
Official liquidity.
Ah, that is what I am saying.
That is lordship has read 75.
Oh.
Uma Devi can be overruled only by larger bench that your lordship has read. I am reading paragraph 61 of official liquidity. This is the position in the Umadevi lawsuit. In state of Karnataka versus Umadevi, the constitution bench diverted in its attention to financial implication of creation of extra court and held that court should not pass order which impose unwarranted burden on the state and its instrumentalities by directing creation of particular number of posts for absorption of employees appointed on ad hoc or temporary basis or as daily workers. So that is the second judgment. Third lordship, I am reading one. 2007 10 SCC 544.
What is name?
This is state of Manipur and another
Oh, that.
versus Moiran. No, Singh. Paragraph 7.
State of Manipur.
Paragraph 7, Lordship. We are of the opinion that in view of the Constitution bench judgment of this court in Secretary of State of Karnataka versus Umadevi, this court cannot direct regularization in service. Since the court has no power to direct regularization, it also follows that it has no power to direct grant of benefits payable to the regular employees. That is the one. Next one is Lordship.
Uday Pratap.
Paragraph 7, Lordship, that's it. Next one is 2011 to SCC 429.
The citation. सामने में तो लिखे हैं. Yes, sir.
Yes,
Paragraph 12, 1, Lordship.
Citation.
This is 2011 to SCC 429.
What is name?
State of Rajasthan versus Dialog.
which paragraph?
Lordship, paragraph 12, 1, small Roman 1. The High Court in exercising power under Article 226 of the Constitution will not issue direction for regularization, absorption, or permanent continuance unless the employee claiming regularization has been appointed in pursuant of a regular replacement in accordance with relevant rules in an open competitive process against sanctioned vacant court. So that is another one. So these are the judgments, which, I mean, primarily indicates that court has no jurisdiction to direct regularization or issue mandamus to the state government, directing regularize the service of a particular employer, Lordship. Then I am coming to this particular issue, Lordship. One judgment, Lordship, I am placing, that is civil appeal number 894/2020. Pension, payment of pension.
Number.
Lordship,
Extra
taken copies from the state, I mean, from website only, Lordship. If Lordship comes to paragraph 35.
Paragraph.
35, Lordship, it's page 30, paragraph 34. Paragraph 34.
Yes.
The common thread in the above referred judgments of this court is that pension is a right and not a benefit. It is a constitutional right for which an employee is entitled on his superannuation. However, pension can be claimed only when it is permissible under the relevant rule or a scheme. If an employee is covered under the Provident Fund scheme and is not holding a pensionable post, he cannot claim pension, nor the Reed Court can issue mandamus directing the employer to provide pension to an employee who is not covered under the rules. Now, Lordship will directly come to a judgment, Lordship, which passed by a full bench of Patna High Court, Lordship, wherein it has been held that works as is not a pension.
Which judgment?
This is state of Bihar versus Bimli Devi.
For which one?
Bimli Devi.
I think all this has been discussed in America Devi.
Yes, sir.
उसको छोड़ दिया और बिमली देवी दिखा दिया.
Then in the subsequent one also I can place Lordship, but therein I have a specific submission, Lordship.
There was a difference of opinion in Bimli,
Yes.
which is the last one, last full bench judgment on this issue.
Yeah, one authored by your Lordship.
वो भी तो दिखाओगे.
But they can, sure I will place this judgment.
Yesterday, Supreme Court says that lawyers should also show judgments
Yes,
against them.
In fact,
Yesterday only.
yes, I had that judgment. Lordship, therein also your Lordship has said that they have no legal right to claim
Have you seen
regularization, Lordship. Thereafter, Lordship has
With a disclaimer that it is on grounds of equity.
yes.
I've said that.
So Lordship, on that point, Lordship, I'll have to place a judgment in that situation, whether which is not legally permissible, can that be allowed by
Correct,
assuming
correct.
the.
Don't be under any illusion that I have authored one judgment, so I will go by that only. I mean, don't be under this illusion.
I'm speaking with that.
नहीं दिखाइए बिमली दिखाइए.
In Bimli Devi Lordship, if Lordship comes to paragraph 31, Lordship. Lordship, why I'm showing this judgment, Lordship, because the rule discussed there in Lordship is exactly similar to our one, Lordship. Paragraph 31.
They say it is not pensionable.
Yes. And if Lordship comes to the rule itself, also pension rules. Taken the 118, please one. One opinion.
Yes.
This is Rule 152, Lordship. And the sector is temporary government service.
Rule?
And Lordship will be whether a works as employee is covered by the sector or not, Lordship. Therefore, that is which is wherein the heading is temporary government service. 152 I am skipping. If Lordship comes to the small Roman 3, no gratuity will be admissible. If Lordship comes to D, to one paid from contingency or one belonging to a works as establishment or any other service governed by separate rules or orders.
Yes.
So the sector, Assam Services Pension Rule, Lordship, there is a specific sector of temporary government employees, wherein Lordship, works as employees are not covered. Next judgment I'm placing, Lordship, this is 2008 2 SCC 310. Paragraph 16, Lordship. This is Punjab Lordship. Initially, it came from Punjab Lordship. Therein also the rule is exactly similar to.
Name Punjab and?
This is Uttar Haryana Bijli Vitar Nigam versus Surji Devi. Paragraph 16. Paragraph 16.
Yes.
The scheme relating to grant of family pension was made under a statute. A person would be entitled to the benefit thereof, subject to the statutory introduce. from their perusal of the provisions contained in the Punjab Civil Service Rules Volume 2 vis-a-vis the family pension scheme, it would be evident that the respondent was not entitled to grant of any family pension. The husband of the respondent was works as employee. His services had never been regularized. It may be unfortunate that he had worked for 11 years. He expired before he could get the benefit of the regularization scheme, but sentiments and sympathy alone cannot be ground for taking taking a view different from what is permissible in law. 17. The statutory provisions as noticed herein above debar grant of family pension in favor of family members as the deceased employee was a works as employee and not a permanent employee or temporary employee. The period during which an employee worked as a works as employee would be taken into consideration only when his services are regularized and he becomes a permanent and not an otherwise. But this is one lordship. Next judgment lordship I am reading.
Mr. Mr. Nayak, you relied on 152, 3, isn't it?
3D,
3D.
pension rules.
Pension.
Now kindly come to 153. Two.
Yeah.
Why this word is used? The members, because this relates to temporary government servants, no gratuity. Now, members of works as establishments are not ordinary.
Lordship, there is one rule of Assam financial rules, Lordship. There is a provision for payment of extraordinary pension. Lordship, the whole sector of works as employees is covered by that rule, Lordship.
So you should also show that.
That rule I am not reading.
Because you are showing 152 treating them to be as a temporary employees. But 152.3.2 says specific to works as employees.
Yes, therein Lordship on provision.
No, that's
It's not ordinary.
You must know, not ordinarily is all right,
Mhm.
but you must know this,
Mm.
and we should also know this. Wound or extraordinary pensions and gratuities are, however, in certain cases admissible in accordance with pension rules.
Mm.
Suppose somebody is wounded or extraordinary pension only for him with no presidential value. All members of the work charge establishment who are not entitled to any pension on their retirement may be granted gratuity in the following scale: 10 to 20 years, 31 years.
Exclusion like temporary employees. Is 153 exclude but 53.
We pay them gratuity, Lord.
Huh?
Works as employees, they receive gratuity, terminal gratuity. They receive. So this is the gratuity. This sector covered pension and gratuity. We give them gratuity. After retirement, that terminal gratuity they receive.
And this is by virtue of section 329 of the Assam Financial Rules.
Lordship will see that note one
got
Lordship
that
of
note
353(1).
Gratuity fully, but
That is financial rules.
gratuity. Unless the governor on this comes from here. And yes,
So that is there. That is a separate. Now, if I am coming to 2023 1 SCC 570. Lots of 4 paragraphs I am relying upon.
153 one is in exclusion to works as establishment. Other than that, this is only to contingency and temporary. It's exclusion to works as. I mean, for the purpose of works as.
In extraordinary
Also,
function,
it's-
also very depending on the. Yes.
Yes. Lordship, in this judgment, Lordship, this is Sunita Burman versus Commissioner, MP, Housing and Infrastructure Development. I'm relying upon 2, 15, 16 and 17. Paragraph 2, Lordship. The admitted fact of this case are that 28/4/1997, Munnalal Burman, husband of the appellant, was engaged by Respondent 1 Housing Board as a master employee on daily basis. By the office order dated so and so, he was appointed in the workers establishment. So he was in workers establishment. The Lordship comes to paragraph 15, 16 and 17. Paragraph 15, Lordship, can be seen. As for the decision in Premsing, cited on behalf of the appellant, the question raised in the said matter relates to validity of Rule 38 of the Uttar Pradesh Retirement Benefits Rule to 1961 and Regulation 370 of the Civil Services Regulation, Uttar Pradesh. In the backdrop, where this court had earlier affirmed the decision of the High Court of Punjab and Haryana in Kesarsan and State of Punjab versus State of Punjab. In relation to perimeter provisions and enacted in the State of Punjab, which excluded computation of the period of workers' ex-service from qualifying service for grant of pension, a three-judge bench of this court examined several decisions on this aspect and on pursuing the note appended to Rule 3A of Uttar Pradesh Retirement Benefits Rule 1961 and Regulation 370 of the Civil Services Regulation held that since the service of the appellant in the said case had been regularized on a vacant post, Rule 38 of the UP Retirement Benefits Rule 1961 ought to be read now in respect of the services rendered by him even prior to his regularization and the period spent in the capacity of a source employee, contingency paid fund employee, or non-pensionable establishment employee ought to be counted towards the qualifying service for extending the benefit of pension to such employees. So that was the issue there in Premsing also. So even paragraph 36 in Premsing nowhere discussed in that judgment itself also. If Lordship comes to paragraph 16, the fact situation in the case in hand is entirely different. The deceased husband of the appellant had remained a workers employee till the date of his demise on 26/4/2016. His services had not been regularized. The office order dated so and so relied on by the appellant to urge that the services of the deceased husband of the appellant had been regularized is being misread, as can be discerned from the first para of the said order, which states that daily wage master employees working between so and named master and therein were being appointed in workers' establishment, and further that there were being the MP workers and contingency paid employees recruitment and Service Rule 1997 was made applicable to them. We have noticed above that the aforesaid rules were never adopted by Respondent number 1, Housing Board, or extended to its workers and employees. Being cognizant of the vacuum.
This all right. All right, yes.
So this is an. In fact, both these judgments were, so relying upon the Uttar Haryana Bijli Vitron Nigam Lordship, our High Court passed a judgment in WA 1 of 2022 Lordship, that is Ujjala Nagari.
This equals.
If lordship comes to paragraph 21, lordship, that is the rule 31 order. Paragraph 21 is the rule, lordship. Paragraph 22, the said rule clearly provides that service of an officer does not qualify for pension unless it conforms or up to the three conditions, namely the service must be under government, the employment must be substantive and permanent, and the service must be paid by the government. 23. Rule 36 of Assam Service Pension Rule 1969 provides that service does not qualify unless the officer holds a substantive office on a permanent establishment, provided that continuous temporary or officiating service under the government of Assam followed without interruption by confirmation in the same or any other post shall count in full as qualifying service, except in respect of period of period of temporary and officiating service in non-pensionable establishment, and the period of service paid from country. 24. In view of above position of law and the decision of the Honorable Apex Court rendered in ML Pensionary, we are of the view that the writ appellants, writ petitioners are not entitled to pension or any relief as claimed in the writ petition, and no interference is called for the impugned order dated 24/11/2021 passed by learned single judge and WPC number so and so, and the order dated 13/12/2021 passed by the learned single judge in WPC number so and so. So this is a similar case, lordship, wherein the wife of a deceased workforce employee paid for family pension.
First must be under government, second employer must be substantive, providing the government event to either or both of the one and two are ever not declared a specific kind of service rendered in non-geography, self-qualified for pension.
Declaration.
Huh?
There is no such declaration. Declaration. That is with respect to opening of your 329 financial rules upon 152. What is declaration?
So इसलिए मैं बोल रहा हूँ that they ought to exercise their power under Provisional 51 and 150 in individual cases and subject to suspend individually and subject to as we may think it.
But this power is only with the governor.
They give a proposal. It is no longer an individual case and subject to suspension.
There is not complete ban.
Complete ban. It is a
There's a difference.
But
Yes.
This part is this condition implication.
Let's believe them.
Okay,
Yes.
next judgment, lordship, I am placing lordship, that is one Mississippi assuming lordship to 2022 18 SPC.
Scheme, there is a scheme of regulation. Probably different scale, at least they will give a scale of them. Then after scale of it, then a seniority list. Seniority list के basis पे उसको pension देता है. ये मर गया और इसका junior को दे दिया. Then after that the price should be given. So this is also very specific provision in the rules. Senior.
No, but this is with respect to the Nagaland rules.
Nagaland rules.
Rule is similar, lordship. Wherein lordship one.
No,
If
rule is not similar. What are you saying with them?
some pension rules, Nagaland.
No, not pensions. In Nagaland, there is a service rule for regularization.
That is not the issue. Issue.
Just so that you can clarify the issue. In Mississippi Assumi, the case was like this. Under the Nagaland rules, once a person gets a scale of pay, initially they don't get, then a scale of pay, after certain period, they maintain a seniority list for regularization. First scale of pay, then based on seniority, regularization. In Mississippi Assumi, husband did not, his service was not regularized. He died, subsequently his junior was regularized. So she says that I should be, my husband service ought to have been regularized. So therefore,
Different.
No, 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 yeah.
Also paragraph 8.
No, that's all right, but the issue is that under regularization policy, service of work charged employees were required to be regularized as per seniority. Now, as and when the vacancy arose or whatever, seniority. At the time of the death of the husband of Nishevi Achumi, he was not entitled for regularization because there was senior strain. No, he dies and leaves space for others to take over. In that case, the wife of this employee, she wanted pension even post death for the reason that had he lived, he would have become. So he says that no, it is not possible.
The point I am trying to emphasize, Lordship, is paragraph 8. It is required to be noted that the deceased employee died in the year 2005. During his lifetime, he never claimed any regularization. That the respondent therein original writ petitioner.
That's one of the facts, but question is this. Here this.
But these are the citations, Lordship, and judgment I'm relying upon. My submission is that.
Case no dismissed is to like very serious only said to dismiss.
My submission would be, Lordship, the service of the petitioner were never regularized. And for not regularizing his service, Lordship, state cannot be blamed because it was only because of the law settled by the Honorable Supreme Court or our High Court. It was not a situation before the authority to continue with the policy of regularization. Secondly, Lordship, for family pension, Lordship, it is the rule only, Lordship. Just it cannot claim pension or family pension. If you claim pension or family pension, you have to show the provision of rule, Lordship. There has to be a right which you are asserting, Lordship. In this particular case, Lordship, there is no such rule which provides for grant of family pension to a works as employee whose service has not yet been regularized. And thirdly, Lordship, that irrespective of other judgment I am placing, Lordship, the judgment of Ujjwala Nagar, that is also a judgment passed by our High Court, a division bench judgment, Lordship. In my humble understanding, this judgment is binding upon this bench also, Lordship. But this is my basic submission.
Yes, Mr. Potter. You have followed, but then you are for the respondents in that case. So let us hear your views.
May I submit, I don't know how this matter came to be tagged along with these matters, Lordship. But in that matter, it's a bit different.
No, different. We are not going to that.
We'll be dealing with it separately because the issues primarily bordered on payment of pension for work charge or regular employees. Therefore, it is here. It is not tagged with this. This requires a separate determination.
Not because this is a review filed by the state, Lordship. So I have to appear in that. So if Lordship decides this matter, Lordship, this is already a 2015 matter. After deciding.
Just we are asking Bhattakur, would you like to submit?
Now, who appears for the petitioner? You,
Lordship,
you have anything to
I'm
say?
appearing in item number 6, Lordship.
Yes. Do you have anything to say? We asked him to argue first, but then if you have anything to say, you tell us.
Let him submit first.
What let him submit? We are asking you in this matter. If you're not ready, we can understand, but don't say let him submit. We have unnecessarily asked him. Mr. Bhattakur's case has not been argued.
Lordship.
Your case has been argued.
Lordship. Lordship. So in this case, the learned senior counsel was supposed to appear, but he is suffering from certain health problems, Lordship. So.
Which senior counsel is to appear?
S. Das, Lordship.
Huh?
S. Das, Lordship. Suffering from certain health problems, Lordship. So given some time, Lordship. Next week, maybe, Lordship, if I can argue.
But then we'll.
Yes, Mahmood. See, issues are same on principle. Issues,
And-
facts are exactly
Lordship.
similar, died during, without regularization. We want the on principle. He has also, facts are not disputed.
Lordship.
Only the principle, whether we can ask for grant of pension when service was
Family
not
pension.
regularized. Family pension. Yes, Mahmood.
Please, Lordship. My lord, my learned friend has cited the examples of very old cases, which are already almost outdated. And I will show your Lordship, I have given the citations for your Lordship, my lord. First, I am telling the story of my case, my lord. I am Lokeshwari Brahmo. I was appointed in the year 1992 as pastoral worker. Thereafter, after 2 years, I was upgraded to the post of casual chowkidar, worked as casual chowkidar. Then my pay was also fixed. I retired in the year 2023 after serving nearly 32 years of service. Now, what my learned friend has said, even in their office memorandum, there are two memorandums, that I will submit later on. But first, I invite your Lordship, kindly see the judgments. What my learned friend has said many things about Umadevi's judgment, but my lord, may I kindly see, first I have given already. So,
Which tell us the citation and name.
yes, now citation we have already given the list. That is first 2024 INSC 1034 Jaggo versus
Name of
Union
the
of
party.
India.
Name of the parties.
Jaggo versus Union of India. Then in this case, my lord, para 12, 13, 22, 25, and 28. Para 12 first, my lord, I am reading. Para 12. Despite being labeled as part-time workers, the appellants perform these essential tasks on a daily and continuous basis over the extensive periods ranging from over a decade to nearly 2 decades. Their engagement was not sporadic or temporary in nature. Instead, it was recurrent, regular, and akin to the responsibilities typically associated with sanctioned posts. Moreover, the respondents did not engage any other personnel for this task during the appellant's tenure, underscoring the indispensable nature of their work. Para 13. The claim of the respondents that these were not regular posts lacks merit, as the nature of the work performed by the appellants was perennial and fundamental to the functioning of the office. The recurring nature of these duties necessitates their classification as a regular post, irrespective of how their initial engagements were labeled. It is also noteworthy that subsequent outsourcing of this same task to private agencies after the appellant's termination demonstrates the inherent need for these services. This act of outsourcing, which effectively replaced one set of workers with another, further underscores that the work in question was neither temporary nor occasional. Now, Lordship, we can see para 22. The pervasive misuse of temporary employees, Lordship would kindly share this. How the Honorable Supreme Court has the pervasive misuse of temporary employment contracts as exemplified in this case reflects a broader systematic issue that adversely affects workers' rights and job security. In the private sector, the rise of gig economy has led to an increase in precarious employment arrangements, often characterized by lack of benefits, job security, and fair treatment. Such practices have been criticized for exploiting workers and undermining labor standards. Government institutions entrusted with upholding the principles of fairness and justice bear an even greater responsibility to avoid such exploitive employment practices. When public sector entities engage in misuse of temporary contracts, it not only mirrors the detrimental trends observed in the gig economy, but also sets a concerning precedent that can erode public trust in governmental operations. Then Lordship would kindly see page para 25. It is disconcerting reality that temporary employees practically in government institutions often face multi-faced forms of exploitation. While the foundational purpose of temporary contracts may have been to address short-term or seasonal needs, they have increasingly become a mechanism to evade long-term obligations owed to employees. These practices manifest in several ways. Misuse of temporary labels. Employees engaged for work what is essential, recurring, and integral to the functioning of an institution are often labeled as temporary or contractual. Even when their roles mirror those of regular employees, such misclassification deprives the workers of the dignity, security, and benefits that regular employees are entitled to, despite performing identical tasks. Then Lordship would come after 3 paragraphs. Denial of basic rights and benefits. Temporary employees are often denied fundamental benefits such as pension, provident fund, health insurance.
We have read.
So, my lord. So that here, Umadevi's judgment has been totally not followed at all. And Honorable Supreme Court has given very long range of issues have been raised. And it is said the exploitation of the employees cannot be permitted. So they were granted pensionary benefits with all other benefits. This is the judgment. Then Lordship would kindly come to State of Gujarat and others versus Tulsi Bhai, Dhanjil Bhai Patel. Only one paragraph is enough in this case. It is unfortunate that the state continued to take the services of the respondent as an ad hoc for 30 years. And thereafter now to contend that all the service rendered by respondents are ad hoc, he is not entitled to pensionary benefit. The state cannot be permitted to take the benefit of its own wrong, to take the services continuously for 30 years, and thereafter to contend that an employee who has rendered 30 years continuous service shall not be eligible for pension is nothing but unreasonable. as a welfare state, the state as such ought not to have taken such a stand. In the present case, the High Court has not committed any error in directing the state to pay pensionary benefits to the respondent who has retired after rendering more than 30 years service. So very clear instruction, very clear mandate of the law. Then, my lord, I am coming, and my lord has also one judgment, Mobina Khatun. My lord was a part, I have not got today in Patna High Court, full bench judgment. My lord, the Chief Justice was the party. I have not brought today, but because I have brought so many judgments of the Supreme Court. Mobina Khatun. Perhaps my lord, yes, yes, my lord, yes, my learned friend has helped me. Here, your lordship, my lord, the Chief Justice was a party. I can listen this. Full bench judgment.
No, I was a member of the bench, not a party, Mr.
And so, sorry, my lord, sorry, yes, slip of tongue.
Still alive, no?
That is your lordship's judgment. Full bench, the pension was provided by full bench judgment of the Honorable Patna High Court. A lot of judgment, my lord. I have more than 20 judgments. I have more than 20 judgments which support the pensionary benefits to be given. I have brought today 6 judgments. If it is included, then it will be 7. And those are recent judgments. And my learned friend has seen the old judgments.
Yes. Non-billable and not know the purpose and philosophy of legislation. Maximum inequality jure malleable best condition possibilities.
particularly from law should be, if known and more automatic, we relate to lie. So support of law negotiable with the sponsor to particularly again on the I didn't choose lashes. That one. No, forget it. अब ये देखिए भतीजा now recent judgment that some moves is then further more this judgment एक करके दर्शी को ले लीजिए चलिए आप
We'll resume at 15 past 2. I'll be going to that building for a meeting and then come back.
I have many other judgments,
Yes, we will be hearing. What do you want? You want an early date? Mention at 4 o'clock when we are rising, we'll see. Mention at 4. Mention at a time when we are rising finally for the day. We'll consider. Yes.
My lords, by continuing my arguments, my lord, I draw your lordship kind attention now to 2024 INSC 621 Ras Karan Singh and others versus Union of India and others. Here, my lord, may I kindly see para 30 onwards.
Yes. अभी जाकिर सब फोटो करते हैं हमारी पसंद है.
Para 30, that was the argument of ASG. Then court is observing like that. Para 35. Having heard the arguments of both the sides, this court believes that the essence of employment and rights thereof cannot be merely determined by the initial terms of appointment when the actual course of employment has evolved significantly over time. The continuous service of the appellants in the capacities of regular employees performing duties
You're reading which paragraph?
Para 30.
30.
Para 30, learned ASG.
Okay.
But later on, my lord, sub-para 5 may be seen. Having heard the arguments of both the sides, that this court believes that the essence of employment and the rights thereof cannot be merely determined by the initial terms of appointment when the actual course of employment has evolved significantly over time. The continuous service of the appellants in the capacities of regular employees performing duties indistinguishable from those in permanent posts and their selection through a process that mirrors that of regular recruitment constitute a substantive departure from the temporary and scheme, specific nature of their initial engagement. Moreover, the appellant's promotion process was conducted and overseen by a departmental promotional committee and their sustained service for more than 25 years without any indication of the temporary nature of their roles being reaffirmed or the duration of such temporary engagement being specified merits a reconsideration of their employment status.
Correct.
6. The application of the judgment in Umadevi Supra by the High Court does not fit squarely with the facts at hand given specific circumstances under which the appellants were employed and have continued their service. The reliance on procedural formalities at the outset cannot be used to perpetually deny substantive rights that have accrued over a considerable period through continuous service. Their promotion was based on a specific notification for vacancies and subsequent circular followed by these. Then Lordship may kindly see para 31.
Yes.
31. As held in Vinod Kumar's Supra, the essence of employment and the rights thereof cannot be merely determined by the initial terms of appointment when the actual course of employment has evolved significantly over time. This court fully associates with this principle and finds it wholly applicable in the present case, especially in light of the administrative orders and board proceedings referred to Supra that have consistently treated the appellants as equivalent to regular government employees. The mere classification of employees as temporary or permanent is not merely a matter of nomenclature but carries significant legal implications, particularly in terms of service, benefits, and protections. In the present case, the totality of circumstances indicates that despite their formal classification as temporary employees, the appellant's employment bears substantial hallmarks of regular government service. The denial of pensionary benefits solely on the basis of their temporary status without due consideration of those of these factors appears to be an oversimplification of their employment relationship with the government. This approach runs the risk of creating.
We have seen this.
My lord. So, your lordship would have seen. Then, my lord, I draw your lordship's kind attention to our High Court's own judgment. The State of Nagaland versus Engfeld Kony Act 2024 1 NLJ 384 by our High Court Division recently 24. That was passed by my Lord Justice Ravin Phukon and Justice Budi Habung. Recent order, our High Court Division order. My learned friend has repeatedly reiterated Ujala Nazar's case, but it is later judgment, my lord. Here, my lord, would kindly see para 21.
The Nagaland rules were different. You can leave
No,
this
rules-
principle same, integration into service. We have understood the principle.
But lordship kindly will go the para 21, 29 and 33. Then lordship would see there are many similarities and that was rejected by the London single judge. But later on division was set aside the order of the London single judge and asked to pay pensionary benefits to the affected employees.
It is under the Nagaland regulation. For regulation, they are having their own regulation, certain criteria, scale of pay.
Every
And seniority of course.
Seniority.
But the ratio of the cases is applicable. That is my only
All right.
prayer. Then lordship may kindly say 2002 2 SCC 420 para 9, Sugandhi Suresh Kumar. Here, my lord, Sugandhi Suresh Kumar, Lordship may kindly see para 9. That is a question, para 9 it was question, kindly see para 9. It is impermissible for the High Court to overrule the decision of the Apex Court on the ground that the Supreme Court laid down the legal proposition without considering any other point. It is not only a matter of discipline for the High Courts in India, it is the mandate of the Constitution as provided in Article 141 that the law declared by the Supreme Court shall be binding on all courts within the territory of India. It was pointed out by this court.
Oh, that has already been official liquidator, Mr. Nayak has already relied on.
Yes, well, that means sometimes they may say that this judgment is not applicable, but those later on judgments has great implications in this case. Then Lordship may kindly see Sipal. Sipal and others versus Nagar Nigam, Ghaziabad.
Shivpal. Yes. This is Sripal.
Sipal.
This is a
Para 14, Lordship may kindly see, para 14 onwards.
Rajkaran, Supal.
The respondent employer may read below.
Yes.
The respondent employer places reliance on Umadevi, so to contend that the daily wage.
Which paragraph?
Para 14, 1-4. Again, this judgment, Umadevi's judgment has been stated here, which my learned friends has repeatedly said, but here Lordship can see. Para 14, respondent employer places reliance on Umadevi, Supra, to contend that daily wage or temporary employees cannot claim permanent absorption in the absence of statutory rules providing such absorption. However, as frequently reiterated, Umadevi itself distinguishes between appointments that are illegal and those are
Yes.
illegal and those are irregular. Illegal and irregular. Those first, the latter being eligible for regularization if they meet certain conditions. More importantly, Umadevi cannot serve.
All right, Mr. Maman. So therefore, you are relying on Jago, Rajkaran, Vinod, and Sripal.
Yes.
Correct.
So, Lordship would see here, I have also given this short note in the morning before the bench stand. So, my lord, these are the very important judgments, which all are later judgments. And Lordships are aware that later judgments will prevail over the earlier judgments. And law is the last voice of the last judge. My lord, yes, to subject to correction. Law is the last voice, last order, passed by the last judge.
And that's a very controversial kind of a statement over which we would not like to comment.
It is.
Normally, the principle is that the judgment first in point of time on an issue prevails unless overruled or modified or recited.
Now, my lord, I will say other judgments
Fact
also.
of the case, larger strength is more important.
Also, in my book, I have inserted, but one, I have got two office memoranda.
Which book have you written?
In my book, I have written some judgments.
In your book, which book?
This is the book.
You have written it.
Which I have written.
Just have, can I have a look at it?
Look, I may give you. I will give 2 copies to your lordships. Well,
COVID. Maybe COVID, what does COVID? COVID and COVID.
What is COVID, Mr.
That
Mahmood?
is my Hindi degree, my lord.
Acha, COVID.
Yes. From Wardha, Maharashtra.
And what is FM?
FM, that is Arabic degree. Arabic degree.
Arabic degree.
Yes, it is obtained from Assam Board of Madrasa, Assam at Shillong. At that time, it was in Shillong.
All right. Yes.
I will give 2 books to your lordships. It is my personal copy. Now, my lord, we have got 2 office orders. Actually, I have not extra copies. That is 12 September 1996, and another is 6 September 2003. I am reading the operative portion. The government servant, who retires after rendering temporary service of not less than 20 years under the government without being confirmed, kindly note down this, in any post is to be allowed the pensionary benefits as available to a retiring confirmed government employees. I asked my learned friend, Mr. Nayar, whether it is withdrawn. He said that no, it is not withdrawn. So I am giving this. Then the same thing has been reiterated in 2003, that in continuation of Department Order number so-and-so, that is earlier office memorandum is quoted, it is reiterated that the office memorandum clearly lays down that a government servant rendering 20 years of continuous service without being confirmed shall be eligible for pensionary benefits.
Government service, government servant.
Well, government servants. Now, whether we should be treated as government servant, because we always discharge the duties like a government servant, number one. Secondly, without any break of a single day, my lord. My lord, without a break of a single day. Continuously almost 32 years service. Kindly consider this.
The problem with you is that Mr. Nayak has made a statement that you were neither serving on a sanctioned post nor vacant post. Nothing. That is the only hurdle.
My lord, that there is a judgment of the Honorable Supreme Court.
What judgment could be there?
Yes.
Now that part of Umadevi can't be diluted.
Oh, no. Honorable Supreme Court said in one judgment that bureaucratic delay in providing something which ought to have been given to the person, that will not deny the justice to that person. Suppose, my lord, I rendered nearly 32 years of service. In between, they proposed my name. They brought me under regular cadre. In my case, I am Lokhi Sri Brahma. My case was regularized. My post was regularized. But later on, they say that it is cancelled. But that cancellation order, it is here, I have annexed.
We cannot say this, but the petitioner, because it's not even going project or something. Petitioner
You will tell Mundia. You will tell Sahini. Basically temporary. Some escalation.
also implement their terms of revision or anything.
I have annexed the order. I have annexed that order. So my post was brought under regular cadre, and that was cancelled later on by them, but it was not communicated to me. So that is violation of principle of national justice. Something has given to me, but taken away without my knowledge. No copy is furnished to me. So that is a question. That is a lordship would kindly see, and we are poor employees. That means
as long as you were in service, why did you not question this? I mean, these are questions which can come up against you. Why did you not question that?
Yes, I have filed representation that bring my post to regularization. I have annexed that also.
Questioning the decision that these are few hurdles, otherwise things are in your favor. I mean, prima facie, we find that you were, though of course you were labeled as work charge, but for all practical purposes, your appointment was permanent. But it was not against a vacant post, sanctioned post, number one. That's a big hurdle for you, Mr. Mahmood. Number two, that you never challenged it.
No,
Filing representation is not what we take notice of. You should have questioned it.
Consideration
well,
is
that was not communicated to me, my lord. When I retired, then it came to my knowledge. And
that is no.
They said this. Then I
No,
filed this case.
There could be some justification or some
State right.
semblance of truthfulness in this, for the reason that
Your
there was no
HLM
monetary disadvantage to you. You were getting all pay, everything.
is there.
But
That
my
is
pension-
wrong.
And in these old days, my lord, after 32 years of service, a man becomes too old to.
What do you have to say that you did not have a service book? It was only service roll, which does not tell you the details. It only tells you how many days you have worked, since when you have worked, whether there is a break or whether there is no
No,
break.
they have not said that there is a break. They have not said.
No.
We are not saying
There
that.
is a service roll or service book. Where is
Service
the
book.
annex?
Yes,
Yes,
there are.
You show us that page.
My lord, that is a
Just
good
a
question.
Mr. Mahmood, what we are
My lord,
telling you,
what?
we are not opposing your case for the moment. We are only telling you that these are the parameters on which it is tested whether you were an employee and your employment partook the character of a permanent or, for that matter, temporary employee who needs to be given all the benefits. Correct. So there are the continuity of service is not what is being disputed. You were. But question is that you remained a master roll worker and thereafter work charge
Yes.
worker. And
Then regularized. My post was regularized, then cancelled without my knowledge.
therefore we will take it that without your knowledge it's all right, but it was cancelled. Regularized रहता तो फिर क्या दिक्कत?
Now, my
So
lord,
these
my
are
lord,
two things which go against you. Otherwise, everything, I mean, the major ground which is in your favor is that you have worked without break and you got pay, you got everything
and
minus.
pay was also fixed. Revised pay scale was also fixed.
Everything, increment.
And my lord, what my,
Where is your service roll or service book?
my lord, that is, of course, I have, whether it is prepared or not, but one,
No, in the repetition that there should be a copy because you have pleaded that specifically.
regarding service book, my lord. That is also a matter of, I wanted to bring your kind attention. Who will prepare the,
They have not disputed on this. Not because of the absence or presence of the integration.
Where have you stated that it was regularized but cancelled?
Yes.
And you were not noticed?
yes, I had said that.
That was the one which then individual. So I will point on the non-individual, not house.
Limited to the facts.
My post was brought under regular cadre, page 32, and it is cancelled, annexure 5.
Page 30, read me page 32.
32, madam,
Mm.
yes. In pursuance of the additional chief engineer's letter, number so-and-so dated 2011-80, and subject to the approval of the Secretary to the Government of Assam, PWD Department, PWD, Dispur, Gauhati, the services of the following workers Chowkidar, who have completed more than 5 years continuous service as on 31/11/1999 against their names are hereby brought to regular cadre under this division with effect from 1/12/1999 in the scale of pay of rupees 2,450. This order may stand cancelled if the government of Assam PWD does not accord necessary approval.
Is it issued by whom?
This has been issued by
The executive engineer.
Executive Engineer PWD Kokrajhar Division.
That was, that we don't take into account for the reason that it was, this letter was by an authority who was not competent to regularize. It has to be government. And number two, it was conditional on government
Yes,
sanction.
that is
So it was not cancelled simpliciter. It was because of the absence of sanction. So it will be assumed to have no existence at all at any point of time.
You read
However,
this
my lord-
cancellation order, that will
But
be the
however,
ground
his
without authority.
copy has been given to me, but
No, no, forget
cancellation,
about that. You read the next page, cancellation.
that is not.
It's not here.
communicated to
It
me.
is subject to the it's subject to the
confirmation
confirmation of
is-
sanction. It is, so we will consider it to be non-existent.
Now, my lord, I have a
That
legitimate
was a
expectation.
very important ground in your favor. But then it is non-existent. The executive
But my
engineer
lord-
can't pass an order.
I have a legitimate expectation that when my post was brought under regular cadre,
Don't stress too far. Legitimate
that's a
expectation
different
cannot be
question.
against law.
No, legitimate expectation, all right. but
nowadays, my
legitimate
lord, I have
expectation-
judgment of the honorable apex
No, no,
court.
Mr. Mahmood, you're arguing on the correct track. You're on a correct track. Don't divert. See, the legitimate expectation principle you can't import here. Pension and pensionary benefits are governed by law. If you're entitled to it, you're entitled to it. There's no legitimate expectation.
Here, my lord, I have annexed another order. Kindly see page 51 of my writ appeal.
जो जिस लाइन पर बहस कर रहे हैं वो ठीक है. Don't get into all this.
So, some persons were brought on regular cadre who are contemporary with me.
That
They
is,
pick and choose.
that Mr. Mahmood is admitted. You know, that is what, that is.
Pick and choose.
Try and understand. That is what is making us, look at it from, we are doing all this post-mortem and we are analyzing it in such detail only for the reason that, the department had thought of regularizing. The government had come up with a circular, all muster roll workers, all work child establishment people, they would be regularized. For some reason or the other, your name did not find mention in that list proposed by the department, which was later understood to be an oversight, and thereafter they made some attempts. But before anything could happen, you died.
No, in his case,
You,
he's
sir,
retired.
oh, that's
Yeah,
not good.
no.
But you retired,
Yes, I retired.
and you never questioned it. Your wife questions it only when she doesn't get the family pension.
I myself is the employee.
कौन सा है?
यहाँ पे ये दूसरा होगा।
कौन बर्मन है?
बर्मन नहीं, ये-
Lecturer from my herself
Correct.
is the
Okay, all right.
My lord, one thing, my lord, they do not like my face.
Your strong point is Jago, Sripal, Rajkaran, Vinod. Why do you want to deviate?
Then I hope and believe that your lordship definitely would consider, there are hundreds of people who are now lying in bed, one Umalal Chhetri. I have mainly 15 cases of this type. The Umalal Chhetri, he is on deathbed. Now every day he telephones me from bed, what I can do.
Forget about all
So
this.
our hope is for you, but
We are
they are exploiting us. And it is not my word, it is the word of the Supreme Court. That casual workers cannot be used as a tool of exploitation. So my lord, lordship would kindly consider this aspect also.
We are. Why do you think we are looking at it in such great detail? We are doing it.
And I may choose when there are also, Supreme Court has also said that when there is no law, but in the mind of the Honorable Court appears that it is injustice, then even court may provide justice. Here, I may show the citation of the Honorable Supreme Court. 2006, 1 SCC 479, my Lord may kindly note down. 2006, 1 SCC 479, para 36, 37, and 64. UP State Brushware Corporation Limited and others versus Uday Narayan Pandey. Here, Honorable Supreme Court said that court always did not wait for any statute to provide substantial justice. If the facts and circumstances say that this person is entitled to get some benefit, then court should provide that without having any statute. So this is one of the classic example. And moreover, my Lord, regarding the case, judicial discipline is an important maxim of law, and the declaration of law by Supreme Court cannot be forsaken under any pretext within the territory of India by any authority or court, including High Court. That is reported in 2004, 5 SCC 568, para 6, State of Odisha versus Dhani Ram Luhari. So there are, and the state cannot take the benefit of their own mistake. Now, in my case, I have said, I have annexed an order, similarly situated employee who were appointed with me or later than me, they have been picked up and they are regularized, they are getting everything pension after retirement, but I have been denied. So my face is not good for them. Their face is good for them. So that cannot be. State cannot discriminate within the similarly situated employees. They must say in one voice. They cannot differ here and there.
All right.
So my Lord would kindly consider all these aspects.
All right. Who else?
In my case, Your Lordship, pursuant to Cabinet decision dated 22/7/2005, Your Lordship, they have started process of regularization of master of workers, Your Lordship. Now, our names were left out, Your Lordship, in the process. Now, Your Lordship may kindly come to page 35 of my appeal, Your Lordship. Appeal. Here, Your Lordship, there is a letter when we were left out, Your Lordship. Then on 23/2/2006, a letter was sent by the Director of Sericulture to the Commissioner and Secretary to Gauhati of Assam. The subject regularization of drop tamar under Directorate of Sericulture, Assam. With reference to Gauhati letter number cited above, I have the honor to resubmit the proposal for regularization of drop tamar labor engaged prior to 1493. These names have been dropped due to typing mistakes during the process of regularization. Now our names were dropped due to typing mistake, but they did not do anything, Your Lordship. Therefore, we came before this Honorable Court. And Honorable Court, when we filed the writ petition, dismissed our writ petition, filed order dated 19/1/2009, which is available at page 62 of the appeal, Your Lordship. And on the ground that in the meanwhile, Jiten Kolita's judgment has been passed, and therefore we are not entitled to regularize. Then we filed a review petition. Now, review order, which is, Your Lordship will find it at 111, our petition was allowed, saying that Jiten Kolita.
Review page?
Review page 111.
No.
Saying that Jiten Kolita will not cover our case. In fact, Jiten Kolita will not cover our case.
My Lord.
After the.
My Lord, I humbly request, I have a matter at court
Please,
of
please,
appeal.
you're
May I
very
leave?
welcome.
My junior would be here, man.
Thank you, thank you.
Alia.
Jiten Kolita, your lordship, that or review is allowed and we are directed to be regularized. Then they prefer an IA seeking review at that particular order, the state. The court says that this is not the appropriate application, then it was dismissed. Then they come with the review petition again, your lordship, and that is in 2013. And that review petition was ultimately on 1/3/2013 was dismissed. Then they come before this honorable court.
That
Now-
last review order page,
That review order, your lordship will find that impugn order 187. Now, your lordship may kindly see the Jiten Kolita for a moment, your lordship. I have 3 copies, your lordship. And your lordship will find the date of judgment of Jiten Kolita. Was 17/5/2006, and our regularization process has started prior to that. And in here, your lordship, and this is pursuant to a cabinet decision, your lordship. And Jiten Kolita was a decision, your lordship, in which the office memorandum dated 1995 was put to challenge. And so far as this cabinet decision is concerned, in para 23 of Jiten Kolita, this honorable court has held full bench. May I read, your lordship?
yes, yes.
Another significant fact which cannot escape our notice is the cabinet decision dated 22/7/2005 for regularization of master roll work charge employees engaged prior to 1/4/1993 as mentioned in the affidavit of Chief Secretary dated 14 November 2005. And the follow-up decision of the state government to create about 30,000 posts in grade 4 category to accommodate the regularization in question. While it is not for us to speculate as to why a fresh cabinet decision had to be taken on lines largely similar to what have been referred to in the office memorandum dated 24/1995, it would perhaps not be incorrect to observe that necessity for a fresh cabinet decision in the matter only fortifies our view recorded earlier that office memorandum dated 24/1995 does not reflect a valid policy decision of the state. However, as neither the aforesaid cabinet decision dated 22/7/2005 has been challenged before us, nor any affected employees has sought for its enforcement, we do not consider it prudent to record our views on the validity or correctness of the aforesaid decision dated 22/7/2005. Neither the manner of implementation of the said decision is a question that has been raised before us. In such circumstances, we make it clear that we express no opinion on the legality or validity of the cabinet policy decisions dated 22/7/2005, nor do we feel it necessary to see any advisories on the correct manner of the execution and implementation of the said cabinet policy decision dated 22/7/2005. Therefore, your lordship, this Jiten Kolita cannot cover my case. And the plea they have taken in the appeal is that since Jiten Kolita has in the meanwhile come, our cases cannot be regularized. No direction can be issued by this honorable court for regularization of the case, your lordship. And ultimately, your lordship, since it was a typographical error for their fault, the rest of all the other employees were given the benefit of regularization.
Separately.
Mr. Nayak, when will you do that? The other case?
Item 15, this Borthakur's case.
This is also an item, petition filed by the state itself.
That's why. When will you argue this? You said that you have some
So far
difficulty.
as this subsequent forwarding of name lodged by the 10 departments.
Oh, that we understand. You said that somebody else or you are arguing in this case. State
not
appeal.
yet.
No, we are taking, we are granting you time.
Lordship.
You argue that case, we'll deal with it separately. This you have
Any
finished.
date lordship before vacation lordship.
दोनों को साथ ही रखना है
इसको separate कर इसको
लिखो WA number 156 of 2025. We have heard. Yes.
No, no, this is in the other case.
No, no, WA number 156.
Ah,
Yes, next.
Item number 9.
List consider हमारा. Delhi क्या रखा हुआ था?
yes. It's a one.
कैसे लिया गया?
Yes, sir. We have.
Yeah, then what will happen?
207.
Nothing remains to be done, my lord.
223.
The affidavit is already clarified, my lord.
Where is the other counsel?
Mr. Chaudhary.
Seniors coming with. So tomorrow कर देता है. It comes tomorrow or day after tomorrow?
As per most continuous. Day after tomorrow.
Day after
That's
tomorrow,
Saturday.
tomorrow is the last day, and it comes on Monday.
Monday. Next Monday, Lord.
Let this matter come up for consideration on your date on Monday.
25. 25. Item 10 to 13.
Okay.
Actually, contraction appointment, they say that this act prescribe regular appointment. They have been appointed contractually, and they have not been given the scale of regular teacher and it is mandate. ये mandate करता है कि इसको regular
They watch 2024 rules. Yes, who appears?
Where is education?
You are seeking quashing of 2024 rules.
Yes, but there are two sets of malad the cases are there. Yeah, our petitioners are malad.
Matter may be taken up?
Some of them.
Why?
There's some difficulty.
Mr.
NJ.
Patanier.
Some urgencies on our part next week, malad.
Here, for the absence of the Mr. Khatniar, for the absence of Mr. Khatniar, learned standing counsel, क्या education
I
department,
think school education.
school education department, these set of सब आइए है ना, these set of
No, no, some repetition with IA.
these
10, 11, 12.
these repetitions are adjourned to वो date वो हम लोग कब डेट रखें इसमें इसके पन्ने वाला कब डेट रखें 11th of June 18th of June
Or 8 series.
Item 23 to 25.
Yes, what has happened? What has happened now?
They have virtually rendered all these petitions
Infructuous. Yes.
This is a classic case where that famous adage comes into play that the operation is successful, patient died.
The stay was granted on merit after hearing.
Now what has happened? The work is completed.
As far as I just
Construction work is completed, my lord, but the contempt is also filed. They have filed a contempt petition.
this is just to save their officials from the contempt. That is, this is the sole purpose of this writ.
My lord,
That's
we
right.
hear it on merit, my lord, in that.
We understand this, but then
We an academic exercise, my lord, as well. Nothing else. No fruitful, nothing is going to, I don't want the judicial time to be unnecessary, my lord, because work is over, everything is done. And even my clients also, my lord, fairly submitting lost interest in this case. Only because my name is appearing, therefore it's my duty to appear and address.
But my lord, the contempt is filed, my lord, the contempt is completed.
My lord,
you're right. It's a classic case where that only because of that stay, entire thing has become infructuous.
I got a stay in the month of October 2021. They, despite the stay, they proceeded with the work with their, my lord, the contractor whom they choose to issue the work order. Thereafter, the writ petition was allowed in 2022 December. They filed a writ petition with a condonation of delay after 3 months. After 6 months, they got a stay. Admittedly, for 6 months, their officers were under contempt. Admittedly, the records reveal, no submission is required.
My humble submission is bid was rightly rejected, my lord, that I will argue. The technical bid was, my lord, rightly rejected. It was not a case of bid evaluation, which was, my lord, which has been held by the single judge. My lord. My lord, the
But what will
response-
happen in between? Even if we held that this was rightly done, then contempt,
there is
we'll
a
say
stay,
that
my lord.
contempt will proceed on its own.
There was a stay, my lord. This has already been stayed, my lord. The order has been stayed.
That period,
Paid after 6 months.
My lord, stay, my lord.
we'll see.
Will up to it will
Not
from the taking itself.
Yes, sir, 23, 24, 25.
1-3, my lord, the order was.
BM. First.
1/3/24, there was a stay.
BN is a 20, Union of India versus BN. BN firm.
किसका जन्म पहले? चेक कर रहा है इधर से अब शुरू कर
What is it?
We have heard Mr. H. Gupta. CGC here. The learned CGC and Mr. M. Biswas for the appellant and Mr. M. Biswas, learned advocate for the respondents. The case relates to a tender dispute between the Indian Railways and the respondents. The firm of the respondent number 2 was earlier sole proprietorship. Which later became an LLP. A tender was issued in the year 2021 for 3 major earthworks, bridge and embankment construction on the new BG railway line in Assam. The respondents had participated in the tender, but their technical bid was rejected for the respondents not meeting the financial eligibility requirement. Of having received contractual payments in the last 3 financial years, along with current year, which would be equal to at least 150% of the tender value, as required under the tender documents. Next, such rejection was challenged by the respondents by 3 writ petitions, claiming that the tender clauses were misinterpreted by the appellants herein, and the past credentials of the respondents were wrongly ignored. It was thus urged on behalf of the respondents that the rejection of the technical bid was unfair, more so for the reason of their having quoted a price which was much lower. The writ petitions were allowed, and it was directed that the appellant ought to reevaluate the financial eligibility of the respondent by taking into account its full credentials up to 13/2/2020, instead of limiting it only to the incorporation date of 9/4/2017. It was directed by the writ court that in case after a redo of the entire exercise, if the respondents were found to have satisfied the financial eligibility criteria and the price and the rates and the price quoted by it is lower, the remaining work must be handed over to them. This was this judgment of the writ court was promptly put to challenge by the railways, by the appellants, on the ground that the learned single judge misinterpreted the clear wordings of clauses 9 and 10 of the tender document, and that such adjudication would only cause prejudice to the already selected lowest bidders who had started their work. It would also halt important public railway projects. The judgment of the single judge was stayed. This court has been informed that in the meanwhile, the work allotted to the concessionaires have now been completed, and the matter now remains only academic. In that view of the matter, we consign this appeal for the reason that the work in question has already been completed. And there'll be no use agitating the issues in the present appeal.
One of the contempt proceedings, contempt
the-
is not before.
Huh?
He's talking, he's mentioning about the
Contempt is
contempt. I
also-
said contempt is not before the court, this court.
No, but
If he doesn't understand this, we are not here to tell him. You can always say before the contempt court that this is over. No, we are not going to tell you what to say, what to do. Mr. Das, please don't make a statement. Otherwise, we are so unhappy with this.
Das.
Gupta, Mr. Sorry, Mr.
I'm
Das.
sorry.
Well, you-
This case,
we are referring to you. I think my vision is at you, no?
My lord, my lord.
So, Mr. Gupta, I'm sorry, not Mr. Das. Otherwise, we are unhappy at the manner in which the order was flouted. It's
let
because
us,
of
let
this.
us close it here.
Let us
Don't-
close
let
it
us-
here. Don't ask us to do anything else.
I'm deeply obliged.
The appeal stands disposed of accordingly.
Item 30.
ठीक है।
Yes, sir.
Leave it in.
Yes, what about new tender के लिए बोला था?
The matter has become infructuous
That's
because
right.
we have been informed by the department that the entire e-tender process,
Huh.
which is the subject of the litigation, has been dropped.
ये हम पूछ रहे थे.
Yes,
Lordship, I am appearing on behalf of Mr. H. Buragan.
Hmm.
Today he is unable to appear as he has
the
the.
matter has become
But
infructuous.
it was the last discussion, you said that they will have instruction whether they are further going to proceed. So this order says to have a fresh tender. They are saying we are not going for tender. Matter ends there.
Take instructions and withdraw this.
Lordship, he has.
With the liberty, in case they re-tender, you will participate.
Lordship, the dacoity took place at his hometown, Lordship, so he rushed there at Tinsukia, Lordship. He just prayed me to adjourn the matter to today, Lordship.
ये देखिए इसमें से-
सब देख लिया?
हाँ, तो वो बोलता है कि हम उनको पूछे
Proceed.
थे कि whether you will go for fresh tender. They are saying this site we have abandoned. So matter is there.
And the adjournment may be allowed, Lordship, for hearing only.
ठीक है, allow करते हैं. You take instructions in the matter. This appeal has become infructuous on account of their disclosure that the site, the question,
Area.
the area where on shop were put to tender, they have abandoned that project. They say that they are not going to do it now. Then
So,
why do we get into all
and-
this?
And the order.
Take instructions and ask him, you see, you take telephonic instructions from him
Hmm.
and come back to us next week
Hmm.
to withdraw.
He will remain present on our next date, Lordship.
Okay.
All right. As prayed for on behalf of the appellant, re-notify on when? When?
Lordship, as your Lordship will.
Okay, next week.
Next
Tuesday.
Next week कभी कर देना.
In the orders column को बोलो. Then it will not come in the hearing morning में खत्म करो.
नहीं, another orders नहीं.
You will pass an order on instruction.
Okay, on instruction.
Hmm.
All right, under the heading orders on. कितना करते हैं? 5th of June.
हाँ.
On 5th of June.
ये ऐसे भी लोग
All right.
प्रीपोन मत कीजिए. ऐसा करोगे तो कितने ऐसे जुलाई के लेकिन इसको बोलना पड़ेगा. AG has also said because AG I think is stable.
I think there was some difficulty. The AG was he had some plans of visiting abroad and there are others. So
David, again, my lord, in June also, 11 or 18th,
no, we have kept it in first week. There was some difficulty.
11 and 18, so 2 years.
Let it remain.
Sir
let it
Sharma, as per consent of both the parties, AG also has some difficulty.
Let it inform to me also.
He should have, but then if he did not do, you can ask
It
him.
was not informed to me also that we have come with a bag and baggage. My lord, it was very difficult to come in such a way. We have taken, since 2024, this case has been going on.
You come from which place?
Well, I'm from Goa.
700
Huh?
700 meters from it, not even a
No, you
meter.
practice in this court only, no?
No. Yes.
Only for that, it is the disciples are also suffering, my lord, in this Satra only. years to years is going on, my lord, in this way, my lord. Maybe they can have a June, my lord. Your lordship, only for that.
You do one thing, you talk to the lawyers and come together, we'll prepone the date. Because in their
I
absence,
shall
we can.
inform to them, my lord, by, give the consent that I shall inform. Your lordship to give it over a short date, my lord.
No, you
Eight-
first
it has
inform
been
them,
done
take their
eight, my
consent.
lord.
Then again,
August.
it will be on the litigant will say he is not here.
Because we'll prepone the date and then on that date time, no lawyer would be available. We'll have to adjourn it. Let it remain, Mr. Sharma. Next date, be very careful.